Why? Who got the strike? Why's the strike? What's going on? So they don't want to hear from me. They want to hear from you or this way. So, what's going on with this YouTube strike thing?
Well, YouTube has this. YouTube has a feature in it, and it's called cuckoldry.
I don't think that's quite the name, but let's
It
go.
is.
Let's go
It
with
is
it for now.
tonight. It is tonight. That's where YouTube sits around and watches other people make YouTube a bunch of money. And then what they do is make decisions with some loose set of terms, and they make them mostly arbitrarily and often incorrectly that someone has somehow violated those terms. For me, in this case, I am not yet aware of what exactly I have done wrong.
So you're on double secret probation.
Yeah, well, this is actually the norm. The normal part of this is you will receive some sort of discipline from YouTube, and they won't actually tell you the exact reason. What they'll do is they'll say, this particular video violates some segment of this policy. And for mine, let me pull it up. I have an idea of what this is about, but I don't know what specific thing it is. And so I was talking to a friend of mine today about and trying to like explain this. This is like when you get pulled over by the cop, right? And they say, "Do you know why I pulled you over?" Which you're familiar with this question.
Oh, yes, yes.
So right now, YouTube asks you to, well, they give you the opportunity to appeal the thing, but they've only given you a general sort of category of infractions that you may have done. So in this case, it was harassment, threats, and cyberbullying policy, which covers quite a broad scope of activity, none of which I have done, by the way, to be very clear. I have not harassed anyone. I don't know how I could harass someone who voluntarily comes to watch my content.
Now, is this initiated by some third party like Mr. Duncan that you had on the other day that I had the painful experience of actually watching?
It is. They do not tell us. They do not tell us.
So it's an anonymous report on a vague law that you don't understand, that you've based your business model on, and you've invested time and effort to produce content, and they are removing your ability to earn money and do a business with no notice, no due process, nothing.
Right. The process comes on the back end, in which I will appeal to a faceless entity with no ability to actually converse or explain anything, no ability to provide context for any particular idioms or hyperbole that may have been used, or jokes or anything, and hope that they speak English. Like not to be crude, but YouTube fishes out part of their community guidelines enforcement to a third party, or to third party companies, some of which I would probably say most of which are probably not based in the United States. And so that poses a particular problem when we come to the use of the English language, or any language, right? Like if I were reviewing Brazilian content and I just had a Portuguese dictionary, it wouldn't do me very good if there was some sort of turn of phrase that was unique.
What kind of Portuguese content you're looking at.
Only the best Portuguese content. But they have this review process and then the appeal process. And so you never know who is reviewing or appealing anything. And you mentioned that it's an anonymous report. It may have been a report. I think in this case, it was likely thousands of them. Likely thousands of reports organized by a particular fucking weirdo on Twitter. In an effort to remove my ability to speak because they didn't like what I had to say.
Now, about, and I'm just acting as a consumer of this type of information and seeing the potential for internet to be a great free speech platform where people like yourself and anybody else can set up businesses, talk, and generate, basically compete with the lamestream media.
Right.
And provide alternative and thoughtful and voices, or maybe not. Maybe you can be an idiot voice, but you're a voice in the internet and people come or like it or don't. But my question is, and I've been out of civil law for way too long, and I know how limited the law is, but it seems to me there's some sort of contractual obligation on the part of Google or YouTube that they are giving you a promise by saying you get onto our platform, provide content, and that they take that business right out from under you. It seems like you've built a business on it. There's some sort of reliance interest, some sort of contractual obligation that would subject them to some sort of injunctive action, some sort of damages action. I don't know. I'm just thinking, what is
No,
educate me on this.
I love the way you think because I think the same way. The problem is all of this, all of technology has been basically dictated by end user license agreements and terms of service, which
But
are
those are adhesion contracts. I mean, they can put whatever they want in piles and piles and phone books full of paper that
yep.
nobody reads. So that to me, there's a consumer level. Now, whether you're a consumer or not, I mean, I know that's a factor because are you a
Mhm.
business or a consumer? In some ways, you're a consumer of this
Right.
product that they're
Yeah.
offering, and that gives you added rights. And adhesion contracts are not enforceable under certain state laws. Now, I'm not sure you're Minnesota, right?
Right. But all this is under California state law, I believe.
Well, even
Uh,
more lefty and liberal and consumer friendly, I would think.
You'd think, but see, they're also very protective of tech because tech is where all their money comes from to fund the courthouses.
But you've got long arm jurisdiction statutes. You can sue them from wherever you want in the jurisdiction of your choice, it would seem to me.
Possibly. Now, I don't know if I'm the right guy to sue or whatever, but what I think is this. You pointed out something very important. These are adhesion contracts. Now, for the benefit of the chat, an adhesion contract is a contract by which someone dictates, one side unilaterally dictates the terms, and it's a take it or leave it sort of option. You can contract with us if you do this. You have maybe the illusion of negotiation, but no real negotiation power. You can't go to YouTube and say, I want a 20%, or I want you to take 20% of your super chats and not 30%. They just won't ever modify the contract. So you
Right.
come up, you agree to their list, and then you come in. And they're actually kind of non-discerning on that. Now, adhesion contracts are supposedly disfavored. I mean, that's what the law says. That's what the Supreme Court says. They're disfavored contracts that should always be read against the drafting sophisticated party. In this case, that would be YouTube. YouTube has billions and billions of dollars. Everybody coming to the contract comes as they are. Most of them are not billionaires. So they come in as unequal parties, and that's why it's supposed to be read favorably. When you combine this with, there's another theory of contract law that some states have, and I believe California has one. It's an implied covenant of good faith and fair dealing.
Mhm.
I have not seen the implied covenant of good faith and fair dealing wielded as a sword against a big tech company in any meaningful capacity yet. But I am waiting for the time when some enterprising lawyer of some sort decides to go to town on this adhesion contract with the good faith and fair dealing clause, implied clause of good faith and fair dealing, and says the courts need to start enforcing these contracts as if they are promises from the tech companies, because they do make a promise. You can use our platform. You can participate in our service if you do these things. Then they get all of the power of enforcement. There's no arm. They get a unilateral decision that you didn't do it. There's no arbitration. There's no neutral mediator. There's nothing that is normally present in a business contract. Because if you're in a business contract, a traditional commercial contract, and someone breaches, you don't get to just decide that they breach and stop performance. I mean, you can, but they could, in theory, sue you for your lack of performance. You have to sue them, or you have to negotiate and do more business, which is often the proper solution. YouTube and these other tech companies don't have that. And I'm waiting to find some way in which we can get that. And I have a feeling that when that lawsuit happens, when the right one occurs and someone actually prevails, it'll be because of good faith and fair dealing.
So is there any other information that we haven't been disclosed that you can disclose?
Yeah, I'll say exactly. I've told you guys what I know about the strike. I will also say the strike was on the video that I did pull down. I had preemptively pulled it down. But YouTube does actually allow strikes on videos that have been removed. If they've been uploaded to the platform, they are susceptible to strikes. I don't know who, or if anyone has reported the stream or not, I would assume thousands have due to the online
What
target.
can you just generally describe that video, what it was that you took down and why? Do you know?
Oh,
Or
it was a long live stream, and there's a point in question where people on Twitter have suggested that I said someone should be put up against the wall and shot in the head,
oh,
which
okay,
I
that was the one that Duncan was complaining about for
right,
so long, and you were saying that didn't happen at all, right? I got
correct.
you. And I don't know. I mean, who
Yeah.
to me,
And
there's a big free speech issue here. You know,
right.
I'm a criminal lawyer. Assault, you need to have the present ability to immediately enforce that threat. So if you say, Nick, I'm going to kill you right now. Well, I'm in Florida. You know, that's
Right.
like, that's not a real assault because I have no present ability to carry
Well,
out that threat.
maybe you borrowed one of Trump's nukes, though.
I have the nuclear codes, right? That I haven't changed.
They're beautiful codes. They're wonderful codes. Joe
Wonderful.
doesn't know what to do with them. No, no, you're right. And I want to be very clear though, because this gets lost, and this can often get lost in the free speech, especially from a criminal defense attorney. And I did criminal defense of terroristic threats as well. I never actually made that threat though. Like I want to be very
Right.
clear. It's not even close. There was never any. First of all, even the if we went with the quote that they used where it said that they should be shot in the head, that's not a threat, that's a statement. But I never said that anyone should be shot in the head because I don't actually believe in political violence in any way. I think people should be dealt with by proper authorities when they violate laws, but that's really the extent of it.
Okay.
So that being said, I don't know if that's actually what the strike is over. It is entirely possible that
That's
YouTube has
unbelievable. That's what kind
right.
of business is this?
It's
See, you know what it is?
infuriating.
It's a monopoly. And here's another idea, because to me, there's treble damages in attorney's fees in antitrust actions, and states have antitrust statutes. So to me, Google and YouTube is a trust. And ultimately, not only am I for vigorous antitrust enforcement against big tech, I'm also for and private suits, which people haven't gotten wind of. I don't know why. There's treble damages and attorney's fees. I mean, come on, that should be like flies coming to, you know
The
what?
I think YouTube or Google is a scary target. In the same way that I think like Amazon or Microsoft, depending on your infrastructure, can be a very scary target. Because if you think about it this way, what Google has done to some people, never in retaliation for a lawsuit that I'm aware of, but I'm sure that that's never happened. Google has not only suspended a YouTube account, but they will go ahead and disable a Gmail account. Then they'll just delete it and remove someone's archived Gmail account. They can delist their businesses from search. The amount of power that Google actually has over a commercial enterprise is rather staggering.
Right.
Law
Well,
firms,
and also I really think if they aren't broken up as a antitrust enforcement action, either private or government, I also believe the government should regulate them as a utility. Because, for example, they don't like you because you're a conservative, right?
right?
So does that mean you can't have a phone? Can they cut your electric off? Can they cut your water off? If they can cut you off of speaking to people and interacting with fellow citizens, that to me is a utility function, and they should be regulated just like a utility. I mean, and that's kind of my thoughts. I've been thinking about this stuff for a lot, and I don't have any great solutions, but this unchecked corporate power over the citizenry, and we haven't talked. I guess we can go to introductions, but politically, I'm very much a believer in the individual.
Yeah.
And Republicans say, well, we're for big business, or Democrats, we're for big government. I'm for none of that. I'm against big government and big business. I'm for the individual rights. I'm called a classical liberal, the constitutional rights and this sort of thing. And when you've got big corporations and big entities threatening individual freedom, to me, individual freedom should govern and the entity should fail.
I agree. And one of the really good solutions I've seen posited by someone who's fairly smart, Clarence Thomas, And one of those interesting thoughts came up about this subject actually, and I guess in regards to like this Section 230 and the ability of corporations to shut people down and to censor speech. This might have been in I can't remember what case this was from, but it was pretty recent. And what he suggested was that there may need to be a time where we apply a standard similar to the common carrier standard.
Right.
And
No, for sure.
and common carrier is this beautiful thing where we as a government, in exchange for some sort of protection for a business, demand something from the business. We go, okay, we will protect you from defamation lawsuits. This is a common carriers, or no, this is what they did for telegrams. Was we will protect you from defamation lawsuits by saying you can deliver defamatory messages so as long as you don't know the message is particularly defamatory. You don't have actual knowledge of it. We will eliminate constructive knowledge of defamation. You would have to know this is defamatory. Typically, that would mean there's a court order on this language of some sort of lawsuit that someone could provide proof. And in exchange for that, anybody who walks through the door, you have to do business with them. You don't get to determine what speech you're sending. You transmit their speech, and we will protect you from that. And the interesting thing is, back in '96, we actually did that for the internet without the obligation of them to provide for every customer. And that was foolish of the government, but it's easily remedied by any act of Congress to just go, okay, if you want that Section 230 protection, you must service all customers. And if you don't service all customers, you're not getting 230 protection, which means that you don't get to ban people for the type of speech that they post.
So pour out an odd bag of bow, more at Lafroig. Spirits flow as the ones who get unemployed. So pour out a glass for the tea, post on Twitter as we hear Lost Planning tonight.